My lady, just before I briefly refer you to Section 11 of the Interpretation Act, can I do one other thing that I forgot to do? I'm not going to take you to it, but I referred to the case of Lumsden, in which Viscount Haldane counselled against conjecture. Can I just give you the reference and no more? It's at tab 10, electronic bundle 455, and it's just a short passage at the top of page 470 that I would have shown you, but I'm not going to go back and do that now. My lady, Section 11 of the Interpretation Act, which I think was handed up just before we stopped for lunch, is merely put before you by me in response to the reliance on the Mantilla case. It's internal page 9 of what I think you've been handed. It reads as follows in subsection 2, marginal notes and headings in a written law and references to other written laws in the margin or at the end of a written law form no part of the written law but shall be deemed to have been inserted for convenience of reference only. So there's a specific provision in the Trinidad and Tobago Interpretation Act that addresses the point which concerned the Supreme Court in that case. My lady, returning now to Section 36, can I just briefly try and show you the limited extent to which Section 36 was ever relevant and the extent to which it is or is not in my submission now relevant. The starting point is the fixed date claim form at page 5 of the record. Where set out, you will see the relief that was sought under 1 and 2. And you've already been told by my learned friend that effectively it was an interpretation summons, and that's what it was. And it was all about whether judges could be appointed under Section 110(3)(b). If you then look, please, at page 108 of the record, where we find the notice of application for interim injunctive relief, you'll see at page 109 on the right the two injunctions that were sought. So the first one, restraining the President from acting on the advice tendered in relation to the appointment of the two judges. And the second one, an injunction restraining and or prohibiting the Commission from tendering any further advice to His Excellency. And potentially that one directed at a prospective breach, I would accept. But I pause before showing you what the judge ordered, simply to make the point that Section 36 was only ever relevant to the question whether interlocutory relief restraining the appointment of the two judges should be granted, because it was said by the state, even if a judge could not come within the terms of Section 110(3)(b, then the Interpretation Act cured that which was done in advising that those two judges should be appointed. So it was relevant in that limited way. If you then look at page 156 of the record, you've already been shown this, but it's paragraph 39 of the judgment, which contains the order which the judge made. It's in the 6th line, accordingly the court hereby issues an order that, not that the President be restrained, which were the terms of the relief sought, but that the Commission forthwith advise the President to refrain from handing over and so on, and the administering of the oath. The judge did not order any relief in respect of any further advice, limb 2 of the relief sought in the interim application. If I could then take you to the appellant's case, which you have, it's page 294 that I'd invite you to look at in the electronic bundle, specifically paragraph 34. where you will see that what the appellant says is that in the present case, Section 36 is strictly irrelevant to the appellant's claim, which is an interpretive summons seeking declaratory relief as to the composition required by Section 110. And then importantly, the appellant does not impugn the validity of any act done by the Commission. And then it goes on to say, if on either of issues 1 and 2, the appellant is correct, the respondent is wrong, the appropriate response is to determine the appeal and make the relevant declarations. Section 36 does not come into it.
But it doesn't come into it now because the interim injunction is ancient history.
Precisely.
Was reversed, presumably the appointments were made.
Precisely.
It did come into it, but it doesn't come into it.
I hope that's the point I was making by showing you the relevant passages.
Yes.
Can I just, though, go on to say that if you could also look, please, at paragraph 36, the appellant also says the precise ambit of Section 36 and its operation in relation to any particular board established under the Constitution may require determination in future cases. For example, there might, in another case, be an argument as to whether or not a failure by the state to appoint the requisite number of appointed members to the Commission amounts to a vacancy. But obviously not this case. So, in short, the appellant no longer contends that any defect in the composition of the Commission renders decisions made by it invalid. It does not impugn the very advice tendered in this case, and it acknowledges that the ambit of Section 36 is for another case. The case now, therefore, at any rate, is not about Section 36 at all in my submission.
Well, are you inviting us not to say anything about Section 36?
Well, my lords, I'm certainly not inviting you to embark upon a detailed consideration of what part Section 36 might have to play in the event of a possible prospective breach or something of that sort, because it's simply no part of this case. I'm not saying your lordship shouldn't allude to the fact that Section 36 was relevant in the context of the interim relief that was sought, and your lordships may or may not, bearing in mind our submission, and this much is accepted by the appellant, see fit to indicate that in relation to past acts, Section 36 is apt to cure certain deficiencies, and I certainly wouldn't wish to go any further than that. That'd be a matter for your lordships. But I reiterate, it's not what this is about. What this is about is Section 110(3) and the qualification or otherwise of judges under that subsection.
Is there not an issue as to whether Section 36 could operate in relation to the constitution of the Commission, in the sense that it requires 5 members?
Well, my lord, we have accepted that the constitutional provision requires a 5-member commission. We further have submitted that in the event of a vacancy, absent, and I was at pains to say this before lunch, any suggestion that that was a deliberate policy or something of that sort, that would be cured by Section 36, and that may not be agreed by my learned friend.
What would be cured? Are you talking about the validity of acts?
The validity of the act performed by the Commission, comprising only 4 members because of the vacancy. Yes.
But could Section 36 excuse a deliberate failure to?
That, with the utmost respect, is not this case on any view, and therefore it wouldn't, with respect, be appropriate to entertain submissions on that, which is a purely academic question.
A continuing failure?
Well, it would depend entirely what it amounted to, I suspect, and then there'd be a nice question as to whether Section 36 would or would not cure it. I can well see that a cogent argument could be mounted to the effect that if it is a deliberate and continuing failure, it could be cured by Section 36, because Section 36 has to do with a vacancy. The circumstances, the ordinary circumstances in which a vacancy would arise. I would accept that, but
Also said against you that it's to do with validity,
well,
the validity of acts of a commission improperly constituted.
yes, I think then the question becomes what exactly is it that's complained of? If the complaint is simply that there were 4 members only and there should have been 5, absent any more by way of evidence of some policy or bad faith or something of that sort, Section 36 would, in my respectful submission, undoubtedly make it impossible retrospectively to challenge the validity of a decision reached by the Commission merely on the basis that at the material time it only had 4 members. Equally, provided it was quorate, 3 or more, if there were some issue as to the qualifications of one of its members, Section 36 would cure any such invalidity. But, my lords, I risk of repeating myself, none of that is this case with respect. And I'm hesitant, therefore, to take it any further than I already have. And as I said at the outset, before lunch, when I embarked on Section 36, I was a little bit surprised by the way this was being argued in light of what was said in the case, which was essentially that it's irrelevant, and this case is about Section 110(3)(b). And with respect, I think that's right. So, my lords, in short, well, my lords, can I just say one more thing? I mean, this is only by way of background, but could you look at page 186 of the record as well? I've already sought to demonstrate the extent to which Section 36 ever came into it, and to make good my proposition that it really isn't what the case is now about. But it's relevant to note also that on page 186 in the judgment of Justice of Appeal Mendonca at paragraph 43, he noted that in his submissions, Mr. Ram-Logan strayed from his pleadings and the case as argued in the court below, and made submissions relating to the number of members that the Commission should comprise. And that's how we ever got the argument about whether it should be 4 members or 5 members. My lords, the composition, apart from the question whether a judge or former judge qualifies under Section 110(3)(b, has somehow now assumed an importance that, with respect, the case as pleaded and as argued doesn't really bear and is not really about. That's my respectful submission. But having said all of that, and I think possibly repeating myself, can I just make my position in relation to the true effect of Section 36 clear? I submit, as the Court of Appeal held, that decisions made by the Commission when it comprised only 4 members due to a vacancy, and there's no basis for saying it was more than that in this case, were or would have been valid. That being the clear effect of Section 36(1)(d) of the Interpretation Act. That doesn't in any way undermine, amend, or erode the constitutional requirement that there be 5 members. It simply provides for the eventuality of there being 4 due to a vacancy. Similarly,
Mr. Clayton says that there's been disagreement on this question in the Court of Appeal. The respondent has advanced different arguments at different stages, and for the sake of clarity, the board should make a declaration.
well, I was going to come to that
Oh,
in
right.
just one moment.
Sorry.
No, no, not at all, my lord. Can I finish with? I mean, that's the point he makes in reliance on Hunt.
Yes.
Well, let me deal with it now. As I understood his position, it was this: that as to the constitutional requirement, our position below had been that it was permissible to have only 4 members. We have reneged from that, and we concede that it should be 5. On the assumption that your lordship...
Not so much reneged as repented.
Repented, my lord. Well, yes, you're right. On the assumption that your lordships agree with my learned friend, with me at this late stage, and with the Court of Appeal at any rate the majority on that point, it would obviously be appropriate in your judgment to advert to that. But that is the question, whether the Constitution requires a commission that comprises 4 or 5 people. It's nothing to do with Section 36. Insofar as you do advert to that and potentially agree with the majority and with us, then that would be a sufficient way of addressing the matter. Because Hunt, and I won't take you back to it, had to do with a situation in which a body had, as I recall, acted unlawfully.
What's your objection to a consensual declaration along those lines, Mr. Stevens?
I'm not objecting to it, my lord. I was saying it would be sufficient for you simply to record it in the judgment. I'm not objecting per se to a declaration. I'm simply saying that it would be a sufficient recognition, as judgments normally are sufficient, to recognise that as to the question whether it's a matter of construction, it's 4 people or 5 people, the answer's 5. Does this actually require a declaration? My respectful submission, no, but I'm not objecting to a declaration.
Very well.
My lord, I just got sidetracked by that before saying the last thing I was going to say. I was addressing my lord, Lord Jones, in relation to our position in relation to the true ambit of Section 36(1). I dealt with the question of the numerical composition in the event of a vacancy. Can I just say that similarly, in the event of any defect in the qualification of a member of the Commission, and I obviously don't accept that that was the case, I would submit, as the Court of Appeal held, that Section 36 has the effect of saving from invalidity any decision made by the Commission, again, provided it is quorate. That being the result of either or both of Sections 36(1)A and or D. Section 36(1)A providing that the presence, providing that the validity of any act done in pursuance of any power of the board shall not be affected by A, the presence at or participation in the proceedings at which the act was done or authorised of any person not entitled to be present or to participate, etc. And D, B, I said D, I meant B. B saying any defect in the appointment or qualifications of a person purporting to be a member. So just assuming for one moment, which obviously I don't accept, that a judge is not qualified for appointment under Section 110(3)(b), and there was therefore a deficiency of that sort, provided the Commission was quorate, Section 36(1)A and or B would cure that.
Suppose one of the 3 was the one who was disqualified. One of the 3 in the quorum.
Yes. Well, I am assuming that there is a quorum which comprises 3 duly qualified people in what I'm saying. Okay. But there is no suggestion that it would have been otherwise in this case, because the evidence is that there were 4 people, and the only objection that is taken is that one, namely the second of the retired Court of Appeal judges, Mr. Humphrey Stolmeyer, was not qualified for appointment under Section 110(3)(b). Therefore, the other 3 were. So I don't need to put it any differently.
The reason I asked the question was because of Appendix 1 to the appellant's case, which suggests that there were 3 members at some points.
Yes, it does suggest that. I don't think it's suggested that any of them were not duly qualified, but if I'm wrong about that, I'm sure I'll be corrected. I haven't seen it so suggested anyway. Would my lady just give me one moment, please? My Lady Black asked me about the qualifications of judges in Trinidad and Tobago. I have undertaken to look at this, and I intend to check that there is nothing more than what you're now being provided with. But in the short adjournment, we have been able to discover this much, that the Supreme Court of Judicature Act provides in section 7 as follows. Sorry. Section 7 on internal, page 14. A person shall not be appointed to be a judge of the High Court unless he is a member of the Bar of England or is an attorney at law within the meaning of the Legal Profession Act and is not less than 10 years standing. A person shall not be appointed to be a judge of the Court of Appeal unless, and so on. Perhaps I don't need to read that. My lady, I will undertake to see whether there are any other regulations or provisions, but that much we've been able to ascertain.
Thank you.
Unless, my lady, I can assist the board further, those are my submissions.
This is a matter of interest. Do you have to be of 10 years standing if you're a member of the Bar of England, or can you apply for appointment right away? Don't answer that.
I'm not going to, my lord. I was trying to think of a way of not answering the question. My lady, those are my submissions.
Well, thank you very much indeed, Mr. Stevens. I think there are no more questions. Thank you. Mr. Clayton.
Thank you, my lady. Just to deal with a couple of loose threads at the moment, our understanding of the position is that the Bar of Trinidad and Tobago was separately run, two professions, until the Legal Professions Act of 1986. The second point I want to...
We've had cases about it.
Oh, well, sorry, I was unaware of that. The next point I wanted to make, and this is relevant to the declaration, the Hunt Declaration, which I'm certainly going to make in due course in a minute, the declaration in respect of numbers, is that you were told by Mr. Ram Logan that in the judgment of Justice of Mandoko, he referred to Deborah Peake's submissions on behalf of the state, which were in favor of 4, and the reference for that was at page 187 of the electronic bundle, paragraph 45. The submissions made on behalf of the President, which I'm reading from the transcript, are these, from a Mr. Delson. My Lord, just for the purposes of correcting the record, I announced my appearance, and then he says someone else was also appearing to the office of the President. My Lord, I have nothing to add. I wish to adopt the arguments of Senior Counsel Peake. So the President adopted as well, and that's quite important in terms of the efficacy of an injunction. If I could, of a declaration. Can I now make some submissions briefly in reply in respect of section 110? With respect, many of the submissions advanced by my friend were somewhat anodyne. We certainly agree that the starting point for construction is to look at the language itself. We also agree there's a presumption that in favor of grammatical meaning, and certainly a presumption that words are chosen carefully. I can debate many things, but I'm not debating that. However, what's striking with respect to my friend's submissions is none of these broad principles were applied, we would respectfully submit, either at all or with any effect to subsection A. And I want to repeat the submission I made at paragraph 15 of the speaking note, because this was something which the state declined to address at all. And if I may say so, one can only, when one draws certain inferences from they're not doing that. And that is that the reference in A, subsection A, to one judge, prevails. One means one. That was a submission in paragraph 15 of the speaking note. And if one means one, then what subsection B says doesn't really take us anywhere at all.
But one can mean at least one or only one. And that's the real nub of the debate, isn't it?
Well, it could, but our submission, I accept it could. I mean, unfortunately, none of this is entirely plain sailing from anyone's point of view. But what we would respectfully submit is that reference in A, taken together with the express reference to it being the judge being an office holder, which is an important and distinguishing characteristic of a judge, means that one does mean one. It means not at least one, but it means one. Because it's important to give effect to words, and if I may drop some of my friend's submissions, and the words in B are very different from A. Now, and as I say, that wasn't addressed at all. Dealing with B, because our submission says that A means what it says, no more, no less, we are in one sense relatively agnostic on the question of how B should be construed, because it's essentially fairly problematic. But it is worth at least acknowledging some of the points which may assist with its meaning. It's worth remembering that the context we're here concerned with is of the Legal Services Commission. There are many, as you, my lords, will know from other cases, the board deals with many commissions in Trinidad. This is about legal services, and that gives, the context gives a meaning. Secondly, it may well be that Mr. Stevens, I think this is right, this is what I'm told, when asked by one of your lordships, agreed that legal qualifications might be practitioners. That, with respect, may well be correct. As Lady Black pointed out, a third submission really, that the phrase an active practice may also throw some illumination onto the question of what legal qualification is. And finally, it may be relevant to note the point which we didn't make, but my Lord Wilson did, about organisations to be consulted. It would seem to make sense, at least in this context, that the consultation is with professional and regulatory bodies. And the use of the plural, I think, may reflect the fact that this was drafted before it was a fused profession. If I could next move on to the Section 36 point. And with respect, we part company with Mr. Stevens very significantly. The first point to make is the pleading point is with respect takes us nowhere, because your lordships will recall, and ladyships, that the point was conceded in the pre-Arxton Protocol period. So it's hardly unsurprising that Mr. Ramlogan didn't make a point about 5 members being necessary. That's the first thing to say. It's then said that there is no evidence to say that there were insufficient numbers, and that, with respect, is again wrong. Could you turn to page 32 of the electronic bundle, the record? And if you have that page, it's the very bottom of the page. And what we're told is, to take it, this is 2015-16, in the column on the right-hand side, 2 retired judges, 1 practitioner. As of the 27th of October 2015, there would have been 3 retired judges until the departure of Madam Justice Seeley, after which the JLSC functioned with only 4 members, and both were appointed pursuant to section 110.3. So there is, quite obviously, there was evidence in front of the court. That was the evidence relied on. And with respect, I adopt, if I may, the observation made by my Lord Wilson. If this was going to be controverted, evidence should have been put in. It wasn't. The next point I want to take up is that my friend has floated a complete red herring in order to try and make some headway on Section 36. What he draws attention to is the fact that there were possibly, although I suspect that's wrong, but anyway, possibly, uncertainty as to how many commissioners there were at the time the President made the appointments under Section 104.1. However, that is not the problem. If you go to the authorities bundle and find, forgive me, I'm in the volume 1, And if you could go through to 325, you'll see section 110. You have that. If you could ask you to turn through to section 111. Section 111 defines the functions of the Judicial Services Committee, so far as you find a functions definition. And your lordships will see it's section 111.1, subject to the provisions of this section, power to appoint persons to hold or act in the office to which this section applies include the power to make appointments on promotion, to transfer, and to confirm appointments. Our short point is that for the period of time which I just took you to at page 30, the Judicial Service Commission were plainly in breach of section 110 because they were purporting to exercise functions under section 111, which, when they were 4 people. It's really as simple as that. And with the greatest of respect to my friend, the fact that it's not clear how many commissioners there were in post at the time of the appointment is really irrelevant. But the point is that this is a judicial selection process. It begins in 2015 and rolls on to 2016 and throughout all that process. But for the slightly, it is striking to note this, that we have a press release announcing there's an appointment of the 5th person, and then a pre-action protocol letter response from the state saying, well, now that there's 5th person, it doesn't matter anymore. Well, of course it matters, because for the whole of the preceding period, a selection process has been in going forth with too few people. So
you're not making the case that this was deliberate, are you?
No, of course I'm not. But what I am saying, I mean, with respect, I don't need to go as far as that. All I am pointing to is that section 100, I mean, it's not a complicated submission accounting. I mean, you only need to count section 110 to see it's got to have 5. I mean,
what do you mean when you say that this was a prospective?
Well, what I'm saying really is this: is that as of the date that the hearings took place, there was a continuing breach of section 110 from the beginning of the selection process until, in fact, its ultimate culmination.
Sorry, when you said from the beginning of the hearings?
The advertisement, I think the advertisements are in about October, November 2015. So, April 2016, forgive me. Is that right?
So from that time onwards, you say that there was a prospective breach, is that right?
I mean, it's certainly, well, what I'm suggesting is, with greatest respect to the Court of Appeal, it's unduly sanguine to say when someone raises a point of some constitutional moment, hold on a tick, we've been going on for a long time with too few members for people to say, well, actually, it doesn't really matter because section 136 of the Interpretation Act sorts it. With respect, that we say in principle that cannot be the right answer. Otherwise, at the end of the day, it's important to remember, forgive me, that section 2, the supremacy section, says the Constitution is supreme. And therefore, in our submission, whatever the circumstances and whatever the scope is for section 36, a court should be slow to invoke it. That's a submission. Sorry.
I just wanted to rewind because you referred to section 111.
Yep.
But section 111 only applies to such public offices as may be prescribed. And,
right.
We can see the ones that it probably refers to because of subsection 2. I just don't know whether it actually refers to judges.
Well, can we come back to it?
I think you've got an answer from Mr. Rumley.
We do have an answer from Mr. But can we? I'm terribly sorry that it's my fault. But can we clarify the answer? But I say with some degree of confidence that since that's one of their core functions, that it would cover the appointment of judges. So. Just to step back, we would, with respect, say that when there appears to be, when the court is entertaining a case where there's an alleged breach of the Constitution, a court should be very slow to rely on ordinary legislation the Interpretation Act as a means of saying, well, it doesn't really matter because there's a quorum. We would also point out that Mr. Stevens has not been as fair as he has been elsewhere in the way he's characterized our case, because we actually don't say what he says in paragraph 35. We make the point of paragraph 35 of our case, if I could invite you to turn to that. If it's the last sentence, it deals with, he read the first bit out, but he said the argument is academic, but this is the important bit, but it was wrong in principle. The very fact that in certain circumstances, section 36 prevents acts of an improperly constituted commission from being retrospectively invalidated ought to have weighed in favor of interim relief, holding the ring until the Constitution's requirement as to the Commission's composition has been established. In fact, we'd actually go further than that, if I may say so. We would say that the Court of Appeal ought to have made a declaration that the Constitution was breached by operating with four commissioners. That's what we say they should have done. They shouldn't have been, a declaration was not precluded by the terms of Section 36. I won't go back through it because you'll just have it in mind. But Section 36 of the Interpretation Act was no prohibition from making a declaration. And faced with a breach of the Constitution, which is pretty important stuff in Trinidad, that's what they should have done. That's the submission. Turning, I think my lords have heard sufficient from me about why we contend a declaration should be made in the circumstances of this case, because of the parties, the difference of the President and the Attorney General taking one side, and the Commission and the appellants taking another side, and then the division of opinion within the Court of Appeal. And in our submission, it would be entirely appropriate. The last point I want to turn to is a short point, which arises in relation to Section 11 of the Interpretation Act and side notes. In our submission, this takes the respondents nowhere. Just invite you to look at the language. 11.2 says, marginal notes and headings in a written law and references to other written laws in the margin of or at the end of a written law form no part of the written law, but shall be deemed to be inserted for convenience of reference only. That's what 11.2 says. Sorry, it's probably lost. The point we'd make, and the point that the Montilla case makes, is it's like explanatory notes in the United Kingdom. Side notes are an aid to construction. It's not our contention that the side note is part of the written law. And it doesn't, with our respect, really assist the board about the scope of Section 36 at all to look at Section 11, because Section 11 is not a prohibition from using side notes as an aid to construction. And indeed, if necessary, we have a case where that was done by the Court of Appeal.
Why are you so keen on this side note?
Well, I mean, it may not.
Defect not to invalidate acts done in good faith.
Yeah.
Why does that help you?
Well, it helps us at least in this sense. When you have, which in our submission on a true analysis, this is where we are, you have a selection process which began some time ago. You have the evidence before the court that there were 4 members throughout the totality of it. You have a concession by the respondents in correspondence that they don't stand on the point. And then you have an appointment at the very end, which is said to satisfy Section 104.1, and there's no evidence to satisfy that points the other direction. In our submission, that is not the circumstance that Section 36 is designed to remedy. That's our point.
Very well, thank you.
Thank you. Unless there's anything else, my lords and ladies.
It appears not. Thank you very much, Mr. Clayton.
Thank you.
Thank you to everybody for their arguments in this very interesting puzzle. We will now take time to consider our judgment and let you know the outcome in the usual way. The board will now adjourn.